Welcome to today's program titled ADA Title III Disability Access Updates, Hot Issues and Litigation Trends. At this time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Min Vu. Min, please go ahead.
Thank you. Good afternoon or good morning to some of you on the West Coast. To all of you who are joining us for today's webinar. My name is Min Vu. I am a partner in the DC office of Seyfarth Shaw and also a leader of the Title III team. I'm so pleased to have with me, actually also physically in DC today, my colleagues, my partners, Christina Lawney, who is from the Sacramento office, and John Egan, who is from our New York office, which is, of course, the center of the hotbed of ADA Title III litigation these days, as he's going to tell you later. From the level of participation that we have today on the webinar, I can see that all of you have ADA Title III top of mind. So we're going to try to basically give you the, the complete picture in 1 hour, which is basically a lot to cover. But we hope to touch on all of the relevant and most current topics. And of course, if you need to reach out to us later, feel free to do so. I also want to plug our blog, which is ADATitleIII.com. We try to report on kind of breaking news, and of course, with our analytical lens applied to it in short bites, so you don't have to spend too much time reading. All right, so let's dive into it. Today's agenda. We are going to talk a little bit about just Title III requirements overview, just to remind you what the obligations are. That kind of provides the framework for some of our later discussions. John's going to cover national lawsuit numbers and hotspots because there's some interesting new kind of developments there. I'm going to talk about what's going on with the Biden administration and the Justice Department's enforcement efforts. And then we're going to dive into all the various topics. I will cover what is kind of a, it's a legal question. It's like what plaintiffs have to do to show that they have a right to be in court to actually sue under Title III of the ADA standing. And because there is a very important question that is kind of pending and there's a huge conflict over it. So I'll cover standing. Christina is going to delve into the very large world of website accessibility, which are quite a few slides. And then I'm sure it's probably what many of you are thinking about on this call. And then I'm going to talk about kiosks, okay, and litigation around that. John is going to cover the novel issues because there are some weird ones. We don't get a ton of them, but they're also quite relevant to some of you who are on the call. Service animals, always a favorite. I don't, there's always some issue with the service animal somewhere. So we figured it would be good to talk about that. And then he'll also, or actually I think I'm going to cover very briefly kind of where we are with the hotel reservations website lawsuits, just a quickie on that. And that's pretty much it. So let's dive in. We're just going to talk about the overview. So Title III of the ADA basically prohibits discrimination against people with disabilities, and it covers that prohibition is in various areas, right? Employment, state and local governments, and it also covers public accommodations, which is what we're talking about today. So public accommodations are, if you go to actually the next slide, just briefly. Okay, a public accommodation is a private business. It sounds a little counterintuitive, but it's a private business that falls into 12 categories. Okay, these are the categories that are in the statute: places of lodging, places of serving food and drink. You get the idea. But I think conceptually, we think of it as places that open their either physical or virtual doors to the public and provides goods and services to them, goods, services, accommodations. So if you think about it that way, if you're doing business with the public out there, you're going to be in a public accommodation most likely. Okay, so going back to the first slide. So for public accommodations, Title III says, okay, you have certain obligations, and it's not just to refrain from treating the person with the disability differently. So it's kind of a unique civil rights statute in that way, because that's not enough. You've got to actually take affirmative steps to level the playing field a little bit to ensure that people with disabilities can have access to your goods, services, and facilities. So on the list of affirmative obligations would be one, to have facilities that are accessible to people with disabilities, and to maintain those features. You know, if you've got a ramp, it's got to be working. If you've got accessible parking, you have to make sure you plow it. You know, it's not covered with snow, and you're not letting random people park in it without enforcing the rules. You know, maintenance is actually important too. Second category is to make reasonable modifications to normal policies, practices, and procedures where it is necessary to ensure that people with disabilities have access. So this is a really tricky one, because it's kind of like there could be standards for your building, but that doesn't mean the inquiry ends there. Under this reasonable mod requirement, there might be other things you might have to do that have to do with your building. Okay, so I'm going to get into that, or you know, with your kiosks, or with your even beds in hotels. Okay, so so it's not kind of so it's a catch-all that can pull in a lot of obligations you didn't even think you had. So we're going to talk about that. The third obligation is to ensure effective communication with individuals with disabilities by providing them auxiliary aids and services at no additional charge. So what's effective communication? It's kind of a lot of big words here, but the upshot is, okay, people who are blind or who have trouble seeing, people who are low vision, or people who are, people who are deaf or are hard of hearing, people with speech disabilities, they're going to communicate in a different manner, right? And so ultimately, the public accommodation has an obligation to ensure, to provide whatever services are necessary to ensure that basically you guys are communicating, that the public accommodation is able to communicate what it normally communicates to the public to that person with a disability. That comes into play when on all the stuff about website accessibility, and especially it's all about effective communication and auxiliary aids and services. As a reminder, private individuals can sue for injunctive relief, that is to make you do what you're supposed to be doing, attorney's fees and costs under Title III of the ADA. There are no damages and penalties allowed in a private enforcement action, but you know, clever, of course, you know, plaintiff's attorneys are always going to add like a state law claim for discrimination, and those will virtually always, okay, have the ability to recover damages, possibly even punitive damages. So usually it's a combination of both. That's very popular, of course, in New York and California, you know, where they obviously have those statutes. And then the other enforcement mechanism is a DOJ, a Department of Justice enforcement action. That will start with an investigation, and then inevitably, if you guys can't agree on a resolution at the conclusion of this investigation, then they can file a lawsuit. And as you'll see, they're doing more of that in the Biden administration. In a DOJ action, the DOJ can seek a civil penalty of up to $111,614. That's very specific. For a first violation, and then $223,229 for subsequent violation. The DOJ can also seek injunctive relief, again, having the court order you to do what you're supposed to be doing, and damages for aggrieved person. So this is different, right? Like private party, you can't ask for damages, but the DOJ certainly can, and they can ask for a lot of people. So that's why a DOJ action is actually usually kind of the worst kind of case that you can get. Next slide. All right, we already talked about what's a public accommodation. So now we're going to turn it over to John.
All right, great. Hello, everyone. Good morning, good afternoon. I'm going to talk about the statistics showing ADA Title III and specifically website accessibility filings, which we publish on our blog, ADATitle3.com, on a regular basis. What you see here are the number of ADA Title III lawsuits filed nationally over time. Dating back to 2013 when we started tracking through 2022. It represents all different types of actions, whether under Title III, whether they be physical accessibility, reasonable modifications, website accessibility, all of that. And you'll notice that you see a pretty steady increase all of the way until this year, or last year, 2022. We saw a 24% decrease. We're going to talk more about that, but this just gives you a historical look. As you can see, even in 2022, which was a down year for the number of Title III filings, still over 300% when compared with 2013. We started tracking at 2,722 lawsuits as compared to last year at 8,694. Next slide, please. Okay, this shows this past year who our top jurisdictions were for ADA Title III filings, and it was New York. And it represents a bit of a sea change. Min talked about that earlier, where New York has become more prominent in terms of the number of filings and is now the sort of hotbed. That may be temporary. I don't know. My California colleague is next to me, so we're going to battle it out. But we'll talk a little bit more about where we see this going. But this just goes to show you a snapshot last year where the cases were filed. Next slide. Okay, the big three. California, New York, and Florida. This shows historically over time. And as you can see, California took a really significant dip this past year. There's some possible reasons for this. A really prolific plaintiff side firm was the subject of a lawsuit, a civil lawsuit by the San Francisco District Attorney's Office. That may have resulted in a slowing in terms of the number of filings. There was an unfavorable decision by the Ninth Circuit in October. The circuit court kind of reversed course a bit later on in January. That could have caused some pausing or slowing down in the number of filings. And I think we talk about website accessibility with my colleague here, Christina. She's going to talk about some really significant developments in California in terms of website accessibility decisions having to do with the importance or relevance of a nexus to a physical place. And so bottom line is that in the last year, California has gotten a bit or more than a bit unfriendly for website accessibility cases, and that may be what you're seeing, whereas New York has become probably more friendly. Lawsuit filings, all bases per month, you see it. There's a dip in April, don't really know why that is. As the year kind of progresses, the number of filings kind of decrease somewhat in November and December, as approaching the holiday season, it's the lowest. Okay, this focuses on website accessibility only, okay? So we're taking out all those other lawsuits on those other bases we talked about, only website accessibility. So look, this is really significant. In 2022, you saw a 25% decrease in the overall number of filings, and we saw a 12% increase in the number of website cases, okay? So what does this mean? It means that website cases are a higher percentage of ADA Title III cases. They're relatively easy to file. You don't even have to leave your home. Unlike a physical accessibility case where you would typically need to test and go to the facility and then file your lawsuit. Here, you can browse a number of websites in a short period of time, and lawsuits are on the way. And so what we're seeing here is significantly the percentage of website accessibility cases is the highest it's ever been since we started tracking. This past year, it was some 37% as compared to 21% I'm sorry, 2021 was only 25% of the total number of Title III filings. Website accessibility filings by the month kind of follows the same trend that we saw with the general Title III filings. Next slide. All right. The number of lawsuits by state, and by the way, let me say this. These are federal filings. These do not include demand letters. They do not include state court litigation. That stuff is much more difficult, if not impossible, to track. We have a very precise methodology where we go through and sort through the number of federal filings based on the dockets that are available to us. We can't do that in state court. And there are a lot of demand letters in California. So that kind of contributes to that. I want to make that sort of caveat clear. So New York is surging. We're seeing cases being filed not only in the Southern District, we're seeing website accessibility cases, for example, being filed in the Southern District, but also in the Western District of New York in Buffalo, and maybe even a few in the Northern District. And it's going to be interesting as a New York practitioner to see how those play out. The cultural landscape, the legal landscape in upstate New York and the Western New York is not quite the same as downstate. And so having practiced in some of those courts and lived in various parts of the state, I'm not quite sure that the upstate judges are going to see it the same way. But I'm going to put my crystal ball away and we'll see, and handing it off to our next presenter.
You have one more chart.
I have one more chart? Okay. If you haven't been convinced already, New York is off the charts. That's it. I'm done.
Okay, before we turn it back over to Ben, I just got to say, first of all, John is going to be the Steve Kornacki of the ADA Title III team. We'll get him some khakis. And for those of you who want to refer to these charts in more detail, they are on our blog, and they do also have the captions that have all of the numbers in detail if you don't want to look at the chart. Ben, take it away.
Yep, sure. Okay, so let's talk about the Biden administration, kind of enforcement and perspective on Title III. I don't think it's an overstatement to say that very little happened in civil rights enforcement during the Trump years, especially in the website accessibility space. We saw virtually no activity in the website accessibility investigations during that time. That has changed during quite a bit, actually, once the Biden team took over. The Biden team is way more active than before. Just from talking to the lawyers that we deal with there, they feel energized, morale is great, people are feeling good, which means that they're very busy and they're, out there doing enforcement. As a very early sign of that, we had the DOJ filing statements of interest. Those are briefs that are filed in pending cases in a number of, at least like 3 or 4 lawsuits, which is a lot for 1 year compared to what was going on before. I want to call out a couple of these because it kind of highlights some kind of thorny issues for businesses. So there was one statement of interest about whether hotels have to provide lowered beds for people with disabilities, who basically, like wheelchair users who would have trouble transferring to a bed, because nowadays hotel beds tend to be higher because I think they're perceived as being more luxurious, thicker mattresses, all that. That's a problem for people with disabilities. So the question was, so the hotel company moved to dismiss the case, saying that, look, there are ADA standards as to what has to be in an accessible room, and there is no standard for beds, all right? So how can there be a requirement for a lowered bed? And the DOJ came in and said, well, wait a minute, just because it's not in that huge book that tells you all the standards doesn't mean that there's no requirement, because, as I mentioned earlier, there's that obligation to provide reasonable modifications or to make reasonable modifications to your normal policies, practices, and procedures. So your procedure might be to have a tall bed, but if a person with a disability needs a lowered bed to use the room, then you need to provide it, okay? So again, stuff that you might not have thought about, but that little reasonable mod requirement can be applied to all manner of things, price, you name it. So anyway, so that's one. Kiosks. The kiosk case, the kiosk case was basically a case against a lab, a company that does lab work, and it involved a self-service kiosk where people check in. Okay, the only problem is the kiosk could not be used independently by blind people. So again, there was a lawsuit that was a private suit, a class action, and the lab company basically said, well, we provide employee assistance. You can like use you can swipe as a blind person, you can swipe the screen, and then somebody is going to provide assistance with your check-in. And DOJ came in and again filed a brief in support of the plaintiff and said, well, while employee assistance might be an appropriate way to provide effective communication, i.e. the check-in, right? In this case, that process did not provide equal access because the three-finger swipe that would call for assistance effectively put the person who is blind at the end of the line as if they didn't have an appointment. Okay, so basically it disadvantaged the person. So again, DOJ is coming and saying that's not effective communication when you're basically disadvantaging the people and putting them at the end of the line. So again, that's, they're very, they're, I mean, not surprising positions, honestly, but the fact that the DOJ is showing up for these things means they're watching everything. All right, they're watching and they're showing up when they feel like they need to show up. So anyway, so that's that's one way they've been active. The other is, there have been a number of consent decrees that DOJ has entered into, and one of the big initiatives here was vaccine appointment portals. This is where you would go to basically sign up for a vaccine appointment. DOJ basically went after a number of those pharmacies that were providing vaccines and required them to ensure that their websites are accessible to people with disabilities and comply with the web content accessibility guidelines, which Christina is going to talk to you about. There was also a consent decree with UCLA Berkeley about its websites, actually websites plural, sorry, not just website, very comprehensive with many onerous provisions. Okay, so again, this is totally on their radar again during this administration. We also saw quite a few settlement agreements. That's another way that these matters get resolved. Settlement agreements in a whole host of different areas. I only included the ones where kind of we kept seeing the same themes over and over again. We had like agreements about sign language interpreters, i.e. they weren't being provided properly, physical access barriers, airport transportation services, testing accommodations, like, if you're going to take like a, SAT or whatever, refusal to treat persons with HIV. This is a common theme. It keeps happening. Healthcare providers don't want to treat people with HIV. Interesting, there were a whole bunch of settlements about healthcare providers not providing healthcare to people with opioid addiction who are basically getting other drugs to take care of their opioid addiction, and also inaccessible campus housing. So DOJ is very busy. What was unusual, I think, about last year is kind of the number of lawsuits that DOJ filed. In other words, usually they don't file a lot of lawsuits because they're usually able to get the businesses to comply and agree to either a consent decree or a settlement agreement. But there were two that resulted in lawsuits. Obviously, they weren't able to agree. Eventually, they did, though. There was one about against a bunch of eye surgery centers, where essentially the eye surgery center was not willing to provide assistance to people in wheelchairs to transfer onto the surgery table. And those folks had to pay more money to get a third-party service to do it. DOJ filed a lawsuit. They eventually did reach an agreement, which is on our blog, so you can read more about it there.
It's also a novel issue, man.
It is yes, okay, exactly. And I'm going to shut up now so John can talk.
No.
So, yes, so that was one lawsuit. And then the other one is against, Wrigley Field, the owners of Wrigley Field, for alleged noncompliance with ADA requirements. They did a big huge renovation of the historic ballpark. And, there's some apparently DOJ thinks that they didn't do it according to the ADA standards. We'll see how that goes. All right.
All right, as we're moving on, as a Cal grad, for any of you who might be Cal or UCLA grads, please ignore the typo. We will fix it when it goes out. We do know that those universities are in different parts of the state, and that the consent decree was with Berkeley, not UCLA. Moving on.
Oh my goodness. Yes, minus the LA part.
All right, hot litigation topics.
Back to you, man.
What's
Okay,
hot?
that's me.
What's hot?
Yes. All right. So very briefly, in order for a federal court to essentially have jurisdiction over an ADA Title III case, the plaintiff has to have standing. Okay. And one of the requirements for a plaintiff to have standing is to have suffered an injury in fact, a concrete injury. And so this question of whether the plaintiff has suffered a concrete injury has come up in a number of ADA Title III cases where the plaintiff is essentially a tester who doesn't really have any, interest in patronizing or doing business with the defendant that it has sued, that he or she has sued. And essentially the courts are divided among the circuits about whether or not the plaintiff has to actually have a desire to patronize the business or not. Okay. You have the First Circuit, the 11th Circuit, and now the Fourth Circuit taking the view that there is no need to desire to want to patronize the business. As long as you're saying you're there to test the business and you plan to come back to test the business, that's okay. And that's enough, which seems a little crazy to us, but that's where we're at. In the Lawford versus, I think it's Aitchison, I'm not even sure how to pronounce that, but in that First Circuit case, the First Circuit basically reached that holding, and the defendant has filed a petition for cert with the Supreme Court, and that is still pending. We actually think that might have a shot because of the split. And then you have, like I said, in the second bullet, the Fifth Circuit, the 10th Circuit, and the Second Circuit basically saying no, just having encountering a problem on the website, whether it's deficient information, as in the two Lawford cases, where the information about the hotel's accessibility was allegedly not enough. So content, right? The content's not enough. Or whether it's I can't actually access information because of my disability. That would be a different kind of case, but a similar concept, is not enough. And because you had no desire to patronize the business anyway. So what if you couldn't get the information, right, or get to it? So those are the questions at issue, and we're kind of hoping that the First Circuit, not the First Circuit, the Supreme Court hears it, but we'll see.
All
So
right.
that's standing.
So, as evidence that we do read your questions and we do care, Sue, this one is for you. Pay attention. We are going to elaborate on website accessibility.
Talking to you, Sue.
And anybody else who's interested in website accessibility, mobile apps, and kiosk, digital technology accessibility issues. We're going to dive into that. As you can tell, we're a half an hour in and we've got other topics to cover. I believe we're going to do a standalone presentation on website accessibility at a later time. So stay tuned for that, where we will go into more detail. For now, here is your high-level overview of the updates. Before the updates, we're going to level set for those of you who are new to it. So you're going to hear us say in any website accessibility presentation we give, not a whole lot today, because again, we're going to be brief, that Title III of the ADA does not state in its statutory language, nor the regulatory language implementing the statute, how a website must be coded for it to be considered compliant with Title III of the ADA. As Min said earlier, one of the key components of Title III of the ADA is that you have to construct and maintain your physical facilities in compliance with the ADA. Those have very, very detailed standards as to how precisely the building must be constructed to be compliant with Title III. We do not have anything similar under Title III or under Title II, which applies to state and local governmental entities for websites applicable to public accommodations. Again, like Min said earlier, public accommodations are essentially private businesses anywhere where the public goes to get goods or services. There is a variety of other laws that might also require accessible technologies. We have some of them here. Section 504 of the Rehabilitation Act, Section 508 is where they actually have what the standards should be. We have state non-discrimination laws. Most of the state laws that actually expressly require accessible technology are applicable either through state contracts or to state entities. Otherwise, if applicable to public accommodations, it's usually through the ADA, and we'll talk about how that is in a minute, because like I said, there's no express statutory language saying how a website has to be coded. Air Carrier Access Act, as well as Section 1557 of the Affordable Care Act and the Medicare regulations, they actually do set a standard in those laws. And then we have some international laws as well, which we're not going to discuss today, but the most prominent one is the Ontarians with AODA, the Accessibility for Ontarians with Disabilities. I always get the acronym wrong, but something like that. You get the idea. So before we get into how websites fit into Title III, since it's not clearly set forth in the statute again as to what you need to do, what's the practical aspect of this? What does it mean for a website to be accessible? Well, at its most foundational, a website that is accessible or a mobile application that is accessible is one that can be used by people with various types of disabilities. We have on this slide various examples of what might be needed on the website so that people with different types of disabilities can use it. We see the vast majority of those lawsuits that John talked about in the charts filed by people who are blind. We also see a small amount of lawsuits filed claiming that people who are deaf or have hearing related disabilities can't use them because there are videos that don't have captioning. But where we see most of the lawsuits by blind people are because the website it'll have pictures, but it won't have text coded in behind the picture telling a screen reader that reads off what is coded on the page, what that image shows. It won't be coded so that someone can use tab to tab through the website rather than using a mouse, and various other things related to that. Again, you can go back and read the slide if you'd like to after for other examples. So how do you code a website so that the screen reader can essentially read what is on the web page, what is coded there to somebody who is blind? Or what are the guidelines? Are there guidelines that a developer or anyone who adds content to a website should follow so that they can have some reasonable assurance that if they do that, the website is accessible? Well, what we call the de facto accessibility standard is the Web Content Accessibility Guidelines, the WCAG, the WCAG, the WCAG, people call it different things, but it's the WCAG guidelines published by a private group of experts in the field called the World Wide Web Consortium. And they've been around for a long time, quite honestly, at this point. The most up-to-date version is the WCAG 2.1 level AA. And I should say it's 2.1. There are 3 levels, A, AA, AAA. But the prevailing standard to follow for maximum accessibility for websites and mobile apps, if you were to ask an industry expert, would be 2.1 level AA. Again, we can go into more detail on another day as to what that really entails. So, as I said, we don't have a regulation or a statute that says your website, to be accessible and compliant with the ADA, must be coded in accordance with the WCAG 2.0 or 2.1 AA criteria, like the Air Carrier Access Act or some other laws actually do say. So we're going to talk about what's on the slide in just a minute, but you might be wondering, if you haven't attended one of these presentations before, okay, then why are we seeing these lawsuits? How does anyone bring a cause of action for violation of the ADA due to a website that isn't accessible? And the way they do it is thinking back to what Min discussed at the beginning of the presentation, is through the effective communication provision of the ADA. Essentially, in the regulations, there are examples of auxiliary aids and services that you may need to provide to ensure effective communication, and accessible electronic information technology is one of the examples listed there. Now we could do a whole nother presentation on effective communication, because what is effective communication, or what might need to be used in the way of an auxiliary aid, varies based on the type and context of the conversation or of the communication. But it is the effective communication obligation. You are communicating with a customer via your website, essentially, that they're relying on in bringing these cases, and that the courts have been relying on in issuing decisions on these cases. So even though we've had this body of case law developing, we still have a lot of businesses and the disabled community saying, you know, this would all be a lot easier if we had clear guidance as to how a website must be coded, and a whole slew of other questions related to that answered by the lawmakers responsible for it. And the DOJ, which is the agency charged with enforcing Title III of the ADA and Title II, started that process. In 2010 through 26, it had an advance notice of proposed rulemaking pending. And then the Trump administration came in and withdrew the advance notice of proposed rulemaking. And then since then, there's been, you know, some back and forth. But when the Biden administration came in, like Min said, they became more active. They've been focused on certain things so far. But we've seen some back and forth between Congress and the DOJ saying, you do something, no, you do something. But now the Biden administration is doing something. So in March 22, the DOJ issued website accessibility guidance. This was significant because it was the first real official pronouncement from the DOJ, other than in statements of interest and consent decrees or settlement agreements, as to what the DOJ really thought on this topic as a whole. It really wasn't anything we hadn't seen in any of those prior sources, however, so it wasn't all that earth-shattering. What we did think, though, was that, oh, well, the DOJ has issued guidance, so this means it's not going to pursue regulations again. We learned that we were wrong. In the meantime, though, some senators kept saying, hey, DOJ, come on, restart that rulemaking. And then in July 2022, the DOJ announced its intent to begin a rulemaking process to enact Title II website accessibility regulations. As you can see here, that announcement said that the DOJ expected to issue a notice of proposed rulemaking in April of 2023, and then for public comments to be submitted to DOJ by June 2023. So we'll be, watching closely for that to come out quite soon. As if you read our blog, you probably saw our opinion, very valid opinion in our opinion, that any business that has a website really should pay very close attention to the Title II rulemaking process and prepare and submit comments, because it is very, 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 very likely that whatever happens in Title II rulemaking process will inform a subsequent Title III rulemaking process. So don't miss your chance to have your input heard. In November 2022, as Min said, the DOJ entered into a consent decree with UC Berkeley about its websites and more. And interestingly, even though, as I said before, Section 504 and 508, there actually is a mandate on the federal government for its websites to be accessible, the DOJ released the first report on the federal government's compliance with 508 and found that many agencies are not complying with the web accessibility mandate. And we'll just leave that there. So we're not going to go into all the cases in this presentation, obviously. So here's the highlights. Here are the themes. First of all, as Min talked about before, I'm not going to talk about it now. I think she mentioned it. Federal courts disagree, as do state courts, on whether web-only businesses are covered public accommodations. The term of art in Title III is place of public accommodations. Some courts say that means there has to be a physical place. Completely web-only businesses cannot be subject to Title III. Others say, well, as long as there's a nexus to a physical place of business. Others say, well, the website has to impede access to the services provided by the physical place of business. In the Ninth Circuit and the California Court of Appeals now, as of late last year, and trial courts as well under those courts. This is California essentially. There must be a nexus to a physical place of business for websites to be covered by Title III of the ADA. New York, John's area there, they disagree, and the judges there say, web-only businesses are covered by Title III. But note, in California, we have a court of appeals, both on the federal level and state level, that have said this. In New York, you don't. You just got the trial courts. Secondly, we've talked about this before, but if you have a prior settlement between two private parties promising to make a website accessible, it's not going to be a bar to a subsequent lawsuit. Consent decree could get you some way there, but prior private settlement agreement will not. Being in the process of making your website accessible usually does not moot your lawsuit, meaning it would not allow you to go to the court and say, hey, judge, there is no case for controversy here, because as Min said earlier, under Title III of the ADA, the only relief available is injunctive relief. And so if there's nothing for the court to order in the way of injunctive relief, the case is moot. But if you're only in the process of making the website accessible, the court's not going to say, yeah, there's nothing I can order here because the work isn't done. The judge doesn't know whether you're going to complete the work, etc. But if you have completed the task, that might moot the ADA claim. Note, if you have a state law claim, different story. If the plaintiff can't ever use the services of the business whose website is inaccessible, the case might be dismissed for lack of standing, like Min talked about before, the standing issue. But note, Min had said that, generally, if you're just trying to get information, that's not sufficient standing. There was a case that came out of district court in New York, I think a month ago, right, where the judge said, this person, even though they really wouldn't ever intend to go to this school, have no interest in that line of education, they wanted information as to whether they might want to, so that's probably good enough for standing. So we're still going to have outlier decisions on that issue as well. Telephone access. There's a couple of courts that have dealt with this. Remember, I talked about this is effective communication we're talking about. So there might be different ways that you can effectively communicate, and some cases we've seen that being proposed as an argument. Our website isn't accessible, but you can call us to get customer service help. The courts pretty universally agree that that is a fact-intensive issue, because if your customer service telephone help is not available in the same times and in the same manners, then that's probably not effective communication. And then ultimately, only a handful of cases have been litigated to judgment on this issue, which is part of the reason why we have so much litigation, because it's sort of still the Wild West out there. I have two slides here, one on Domino's and one on Winn-Dixie. You can read about them later. The only reason why we have them included is because both of these cases were quite the saga, going up and down from the trial court and appeals courts, and even petition to the Supreme Court, and both resolved in 2022. Domino's settled in 2022 after all that litigation, and Winn-Dixie, the 11th Circuit essentially denied a petition for reconsideration of its own dismissal of the case, dismissal after all this litigation as moot, because after all that time, the website was accessible, so there was no longer a case or controversy. So strategies for avoiding and defending website litigation: code your website so it is accessible, WCAG 2.1 AA, as well as your mobile apps, and maintain them that way. Have an accessibility statement, not required by law, but absolutely a best practice. Train anybody who has any control or responsibility for touching any of the content or coding, as well as customer service folks. Put accessibility into your vendor contracts. Take care with third-party content that you use to provide your goods or services. And as I mentioned a minute ago, think about 24/7 telephone customer service.
And consult with knowledgeable counsel.
Yeah, really, it does help to know folks who really know this stuff inside and out. Here's your CLE code, Seyfarth Shaw, SS, not Seyfarth Shaw, just the letters, SS 9612, SS 9612. Kiosks, men.
Yeah. So one thing I do want to say about the Domino's case is that even though it did eventually settle, I mean, it did go to summary judgment or partial summary judgment, and the judge did find that the website was not fully accessible to people with disabilities and rendered a judgment for the plaintiff after a zillion years of litigation. And also the court said, kind of relevant to the telephone access issue, Domino's did implement a 24/7 telephone line that people could call, but apparently, the judge found that it basically took too long for somebody to actually be able to place an order. So the quality, this is the thing, and this segues to our kiosk kind of discussion, is that if you're going to provide some alternative to letting the people do it themselves, like with accessible technology, then the expectation is the quality of the experience has to be equal, right? So talking about the kiosk litigation again, I think we're all seeing a proliferation of self-service kiosks all over the place, right? Car rental, hotel check-in, you go to the airport, you want to order some food. It's all about doing it yourself these days, and or checking in at a lab to get lab work done. So then the question is, does the kiosk have to be basically accessible to people with disabilities so they can use it all by themselves? We already talked about the DOJ brief filed in that kiosk case about how basically it was not accessible. They provided employee assistance, but that really was not equivalent because those people had to go to the back of the line. So that was not, in the DOJ's view, okay. And that matter is actually went to trial, and the court is actually deciding the case as we speak. But in a different, the bottom line is, as we survey the landscape of kiosk decisions, ultimately, employee assistance is still a possible option for complying with the law. So if you have an inaccessible kiosk or some other device, like in the NFB versus Walmart case, it was a point of sale, a self-checkout device that could not be used by a blind person by themselves. But in that case, there was excellent evidence that the employees were providing the required assistance in a prompt fashion. And you can see that working at a point of sale device, because when you go check out at the grocery at the self-checkout, there's always somebody hanging out there watching you. Make sure you didn't slip in a few extra groceries. Well, or because the machine never works the way it's supposed to, right? So they're already there. You've got somebody stationed there. So the employee assistance is probably going to work. Okay. And that's great. But the bottom line is, when I get this question, I tell the folks, look, number one, your employee assistance has to be really prompt and really good, and you can't do it when the assistance involves the divulging of private information belonging to the person with the disability. So when you're talking about a kiosk that deals with health issues, health data that you're inputting, the employee assistance is not going to cut it. The other challenge with employee assistance is that, you're counting on those employees to get it right, which doesn't always happen. And even if they did, okay, you get this lawsuit a year later. Is anyone really going to remember if they provided assistance to that person at the kiosk a year ago? I mean, really? How hard is it going to be to actually prove your affirmative case? So if you can't remember or you can't find the employee, then the only evidence in the case is going to be the plaintiff saying, I got bad assistance. And what are you going to say in response to that and to defend your case? So it's a tough way to go if you're going to go employees. It's possible, but you got to do it really well. Okay. I think we're going to novel issues next, right?
All right.
Yes. All right.
Novel issues. Okay, away we go. The first bullet point, you have serial plaintiffs. I'm not going to talk about these folks, but we do see these folks continuing to bring a significant number of cases, and you have right there on the screen the types of matters that we're seeing. The issue of drive-through procedures for deaf and hard of hearing folks, really folks who are deaf. So, the drive-through, you have a menu, you have a speaker, you have communication that's audible, right? So how are you effectively communicating with those individuals? You need to do it through another means. And how do you do that in that context? There's some litigation over this. There needs to be perhaps a notice. Folks need to know to drive up who are deaf. And the folks at the window need to be prepared to have an effective communication, exchange of notes, other kinds of methods that are appropriate for that type of communication. But we're seeing some litigation on that. On the topic of drive-throughs, you have an obligation to maintain your accessible features. Accessible parking that's striped blue with signage with the ISA, and that has an adjoining access aisle that's striped for purposes of transferring in and out of a mobility aid. You have to keep them clear. You can't have snow piled up, for example, for weeks on end, but you also have to be careful if there are obstructions, like, for example, people who are blocking those spaces because they're online for a drive-through. So the drive lane blocking accessible parking, inhibiting the ability of people to get to this parking. This is parking that should be on the shortest accessible route to accessible entrances, and in fact, it may be in close proximity where you could have queues of lines. All right, so that's another novel issue that we're seeing. Next slide, please. Transfer assistance at surgery centers. Min talked about this at the outset. I'm not going to cover it in great detail. But the consent decree against, I think, 24 eye surgery centers in the state of Arizona, basically DOJ took the position that what the business was doing was wrong, and that was requiring that patients for surgery out of their own pocket go through a third party, get taken in on a gurney if they were wheelchair users or had mobility disabilities, and pay for that out of pocket to have their eye surgeries. The DOJ basically said, and this was memorialized in the consent decree, an individualized process so that, for example, accessible, transfer equipment could be used, a Hoyer lift, so that individual with the disability wouldn't have to bear the cost of that. It raises a question as to whether this is a reasonable modification, for us anyway, in reading the consent decree. Is it a reasonable modification? I think it might be significant. This is a surgery center as opposed to a general practice. General practice doctor going to have a Hoyer lift, which is a lift used to transfer people safely, or have staff trained to assist. It depends on context. But this consent decree involved an eye surgery center. Interesting whether the DOJ or the advocacy community then pursues other types of medical providers along the same theory. Ridership eligibility for amusement parks. Amusement parks have requirements with regards to the safe operation of rides. You cannot screen people out with disabilities unless it's based on legitimate safety requirements necessary for safe operation. Can an amusement park rely on manufacturer guidance, or do they have to do their own independent inquiry? These are some of the things that we're seeing. Courts aren't necessarily in agreement, but we got to move. Let's go.
Yep. On that though, real quick, other powered mobility devices, we sometimes see some interesting ones coming into retailer stores, etc. Same principle. The rule is that you have to allow people with disabilities use other powered mobility devices if they can safely do so, but you can't just assume. You have to have like an actual substantial reasosoning behind your decision.
And there are regulations on OMPDs and how to handle them. All right, service animals, okay? I'm gonna do this really fast. I'm gonna do this in a minute. Because we gotta move. All right, service animals. We see things like this come up all the time. People are utterly confused. We do a lot of criticizing of DOJ on our blog. I think it's well-deserved, but in this instance, I think people need to read the DOJ guidance because it's crystal clear. And if you read it, I think you'll understand this, but I'm gonna do it real fast. Service animals are a dog, or in some instances, a miniature horse, that are trained individually to work or perform tasks for the benefit of an individual with a disability. Think seeing eye dog. Think an animal that could pull a wheelchair, a dog, for example, that can pull a wheelchair, intervene when a person's having a panic attack. It's not just necessarily a blind person. These animals can be trained to perform tasks. An animal that's just there to support your emotional well-being, that's an emotional support animal. That is covered in housing under the Fair Housing Act, but it's not covered under ADA Title III in places of public accommodation, okay? So service animals, dog, some cases a miniature horse, individually trained to perform tasks or work for an individual with a disability. What can you ask? You can ask 2 questions and only 2 questions, okay? Is that animal required because of a disability? And what tasks can that animal perform? That's it. If the person answers those questions, they come in. You can't ask for a certificate or registration. They're worthless anyway. You can buy them online for $50. You can't ask for a demonstration of what work or tasks that animal is performing, all right? You can't do that. You can't get into specific invasive inquiries as to what kind of disability the person has. Maybe that individual has a psychological or psychiatric disability that is invisible, okay? You cannot probe the nature of the disability. Where are they allowed to go? They're allowed to go everywhere the customers are usually permitted to go. They can't necessarily go in the back of the house in a restaurant, all right? I don't think it's cool to have them sitting on top of the table when you're eating at a restaurant either, right? They can sit beside you, all right? And these are the kinds of things that are set forth in that guidance that I would commend to you all right? And we talked about some of the tricky issues, but let's move on.
Other tricky issue?
Oh no.
Where's the line between emotional support animal and an animal that is specifically trained to perform tasks for somebody with a mental disability? That can be a very tough line. Also, don't forget that you have state laws potentially as well. We're seeing tons of service animal issues come up in employment right now as well.
Oh, yeah.
And I'm just sad that we don't have our picture of the miniature horse.
Yeah, real quick. State law distinctions, right? In some states, service animals in training are protected, okay? So keep that in mind as well. And even if it's an animal that's performing emotional related support, it still requires training. Can you ask for the training records? No, you have to ask the question, okay?
Yeah, and it also, you cannot require it to wear a vest or a harness, and you cannot discriminate between breeds. I've seen that actually come up a lot lately. Right. And so the key to this, we haven't hammered this, this presentation, training your frontline employees, because often they assume they know what the right thing is, and the only right thing here is what John said, teach them how to ask the 2 questions.
2 questions.
All right.
Yeah, we just to add to that, I mean, there was one particular complainant person, whatever, who's been calling many businesses to ask about what their service animal policies are, and it's astonishing, or can they bring the service animal to the hotel? And it's absolutely astonishing to me the kinds of responses that actually that person was getting. We think he's a shyster, but you know what? He was definitely getting bad answers to his questions.
Mm-hmm.
Well, yeah. He was baiting the people too. I mean, some of it you can see he really was trying to trap people into saying the wrong thing.
Yeah. Yeah.
Training. John, can you say the 2 questions again for somebody who asked a question?
Sure. Okay. Ready? Welcome to the restaurant. Is that animal required? Because we don't permit pets, but of course service animals are welcome. Is that animal required because of a disability? Answer should be yes. Okay. What tasks or work has the animal been trained to perform for you? Well, the animal basically picks things up that are on the ground for me because I have issues with my back, and the animal's been trained to do that. Okay, welcome. All right.
Don't engage in the conversation about the back
Right.
injury.
If the answer is that's none of your business, okay, then the answer is okay. I can't allow the animal to come in, all right, but you're welcome to come in without the animal. Make sure the person's welcome without the animal. That's in the guidance too.
All right.
Yep.
Hotel reservations websites, and then we've got 2 minutes.
Yeah, so just very briefly, if we have any hotel folks here on the call, essentially the ADA regulations contains a requirement that you have to describe the accessibility features of your hotel on your reservations website, so that people with disabilities know and or can make an informed decision about whether your hotel is right for them. Okay. And also you have to actually describe your rooms, your accessible rooms, with sufficient information so that people, again, can decide if that particular room type is good, is going to work for them. Okay. And so there was a law firm in Southern California that decided to file like 550 lawsuits in California, basically claiming that all these hotels were not reporting enough accessibility information on their reservations websites. The good news is we fought that battle and pretty much won it. The Ninth Circuit, after like I don't know, 90 district court decisions in favor of the hotel world, and many of whom are our clients. The matter went up to the Ninth Circuit, and the Ninth Circuit pretty much said what most of the major hotel companies have been doing all along, which is that for a hotel room, for example, you have to provide the room type, number and type of beds. You have to tell the customer if it's mobility or hearing accessible or both. And then if it's mobility accessible, then you have to tell the folks what type of bathing fixture is in the room. Is it a roll-in shower? Is it an accessible tub? Is it a transfer shower? Because that is really important to people with disabilities. So that pretty much is it. And I think we're at the end of our program exactly at 2 p.m. Wow,
Yeah,
that's
we
fantastic.
got some great questions on certain of our topics here. Again, a lot on the website accessibility. We know that's a hot topic. We'll do a follow-up standalone on that, but feel free, on the screen here is again the URL to our blog for you to follow, and feel free to follow up with any of us with questions.
Please do.
Yes, and thank you so much for attending. It was great to have you. Have a great day.
All right, thank you to our presenters. This concludes today's webinar. Thank you for attending.